Good evening. I'm Sandy Thomson, the host of Life Ahead, but this is your show. I do want to make sure that you understand that. I'm going to be asking our guests some questions tonight, and our main topic is going to be guardianships, but you see a phone number on the bottom of the screen, and that's for you to call in and ask your questions. That's what we want to try to do, is give you information that you're curious about, that you want to hear. Now, I do have some very qualified guests this evening in this topic. We have, again, guardianships as the main topic. And if you'll look over here, we have Jesica Thorson. Nice to have you back, Jesica.
Good to be back.
You see her all the time here on Life Ahead, so you probably recognize her out on the street as well. Jesica is an elder law attorney, so she is going to cover that legal base for us. And our once-a-year minimum guest is Magistrate Phillip Houk.
I look forward to this all year long. It's always great to see you, Sandy. You never age, and
I think the same thing of you.
We're both welcome to our mutual fan club.
Exactly.
Absolutely.
Jesica will catch up with us in another decade or two.
Right. Got a ways to go. But.
Magistrate Houk was just telling me right before the show that you're the longest-serving.
I think we.
Is that right?
This isn't for certain, but we believe that I'm the longest serving active judicial officer in the state of Indiana, going on 38 years.
All right.
With the Allen Superior Court, for what that is worth.
It's worth a lot.
I guess it's worth a lot in that I've seen a lot. There's no doubt about that.
Right, exactly. So about anything I ask, you will have dealt with that at some point.
But it's also amazing how new things come up.
As society changes.
But not as often as they used to. I've seen most everything, but I always go, wow, I've never heard that one before. And the lawyers almost fall down when I tell them, I go, I've never heard of this one before. They go, you haven't.
Kidding.
We're all in trouble then. So, but yeah, I've been around for a while.
Good. And I think we talked about, because of his length and service in that capacity, you started when you were 12. Is that what you told me?
12.
13, somewhere
12 or thereabouts,
yeah.
Rounded up maybe a little bit and then add some. But
I have no doubt in 10 years we're going to be sitting right here.
Yes.
I'm all for it.
I hope so, yeah.
Let's just get it on the calendar.
No one will have caught up with you. Okay, Jesica.
Yeah.
Guardianships are going to be our main topic. And we've spoken about that before on the show, but we can take different directions. If those of you at home have some questions you'd like to ask, 969-2720. Guardianships, definition, and what's the difference between a guardianship and a power of attorney?
Sure. So a power of attorney document is one where an individual is actually going to sign a document giving the authority to somebody else to make decisions for them if they were to become incapacitated.
Okay.
So there's lots of different types of powers of attorney. There's most common people talk about as a durable power of attorney.
Yeah, what's the word durable mean?
Mm-hmm. It means it goes beyond your incapacity. So it's a document that's effective as soon as you sign it, and that it goes beyond your incapacity. You can use it. Oftentimes I see people will use it if they're at home and maybe limited mobility, and they're fully capacitated mentally, but they have limitations in their mobility, and they want somebody else to take action on their behalf.
Does everybody name them durable power of attorney, or could it just be power of attorney?
No.
I don't understand the difference.
Yeah, so there is a thing called a springing power of attorney, which
a what?
A springing.
Springing, okay.
Yep. And so in order for that document to be effective, you have to have usually a doctor's note. Sometimes it'll say 2 physicians. Sometimes it'll even say what type of physician that you need to have in order to make that document effective.
Okay.
There are also powers of attorney that are limited. So you could say this power of attorney you can only use this power of attorney for the period of time that I'm on vacation in Europe. So it's available for a month or whatever the case may be. Or maybe it's limited to a particular transaction, say a real estate transaction. I am letting you take care of the sale of my home for me, and once that's done, your power is over. So it really kind of depends what your goal is with that power of attorney to determine what type of one you use.
You know, I think one time we talked about in referencing powers of attorney, I guess that would be the plural, wouldn't it? Powers of attorney? Power of attorneys.
Powers of
attorney.
I think that sounds good.
Okay, sounds good to me too. There, we answered that question. That a lot of times people just think of that as what elder people might do, and they do their will, they do their power of attorney, living will, whatever. But I think it was you, Jesica, that said, nowadays, a lot of people do that if they're going to be on vacation and they have small children, or they're going to Europe or someplace far away. I mean, you never know. So maybe they'll name a power of attorney just for that vacation time.
Yep. And as soon as you're 18, I recommend that you get a power of attorney, because you're a legal adult, and so your parents can't make decisions for you anymore. So I'm at the age where I have kids who are graduating high school, and so this transition is something that's very much happening in my day-to-day life. And so those are things that even as a graduation present, I'm suggesting, hey, here you go. This is what I think you should get.
I'm going to give you
that. Pretty much.
That's great. Thanks.
Now, there's something new.
Special.
For graduation present, they get a power of attorney.
POA, yeah.
Exactly.
Powers of attorney also, though, they can be super limited.
Like what?
And
What
they
would
come,
be
and
less?
they come up like sometimes when you're buying a car and there's documents you have to do, and they say, oh, we need you to sign this power of attorney so that we can file the paperwork for you. I've seen things like that. I mean, you can dial in a power of attorney to really accomplish, to designate about any type of authority, broad or narrow as you want. So
Okay,
it can be a very flexible document.
Why would you do that instead of a guardianship then? Just to give you the power to handle financial situations?
Well, we'll talk about guardianships, but you may
Okay.
want to, Jessica may want to tell why, when you counsel your clients, that they need a guardianship as opposed to a POA.
Yeah. So a power of attorney is you are signing that document, and you are making the choice of who you're naming in that document.
Okay.
And so for me, it's a lot about making sure that this individual has control about who is making those decisions for them. They can name co-attorney in facts. They can name, I want this person, then the secondary person. So it's really trying to figure out who they want in their life to make these decisions. There are times, though, the person doesn't have capacity anymore, and so we have to go get a guardianship. And who petitions the court for the guardianship may not be the person that individual wanted to be making decisions for them.
Ooh, yeah, I could see that scenario happening. So then what happens?
Well, that's where, when you petition the court to be appointed somebody's guardian, everybody in the family, for the most part, is going to get notified. Lots of different situations about who gets noticed.
And they come before you?
Eventually, they'll probably end up, in fact, undoubtedly, if you're in Allen County, you're going to end up in my court. And then, see, the court grants the guardianship. The person who, they're called the attorney in fact, they're the ones that grant the power of attorney themselves. Like,
You don't have anything to do with the power of attorney?
no, not at all. That's something that you could give to your brother.
Okay.
But the court has to approve the guardianship, so your authority comes through the court if you're appointed as a guardian. The POA, one of the problems sometimes with POAs is that they can be revoked. So I can grant a POA, but if I'm perhaps having difficulties with making decisions and things like that, I may be making decisions against my own interests, and I may just revoke the POA, and the family may say, oh, you're squandering money doing things like that, making poor decisions. We need to get into court to see if the court agrees that you need some authority that comes through the court that gives us authority to protect you from yourself.
So, like, if somebody's the power of attorney, say, and their siblings or somebody in their family petitions the court or comes to you and says, I don't think they're being fair, or they're not making good decisions, then do you have the right then to call that person in and say, you're out, you're not going to do it anymore?
Well, you mean the POA?
Yeah.
Yeah. Absolutely. In fact, under Indiana law, somebody that holds a power of attorney, and many times they'll voluntarily resign. But if they don't, they have to get notified.
Okay.
And they may defer to somebody else to say, no, I think this person. And usually families do work together, and their families or friends or whoever, business associates, they do work together in the best interest of the person. Not always, but in any event, in order to revoke a power of attorney, it can be done by agreement. You can voluntarily resign as a POA, or the court has to give you notice, and you can come in and argue that it shouldn't be terminated. And I have to make a determination what's in the best interest of that person.
What do you look at? What do you look at to make that decision?
Well, it's a lot of times the reason why you're in court on the guardianship, a guardianship petition, is because there have been allegations that the POA is not properly doing their job.
I see.
Not being attentive enough, or maybe they're abusing the authority that they have under that power of attorney. And that's the kind of evidence that comes before the court at that point.
How long, and maybe this is for you, Jessica, in settling an estate, and say somebody has a power of attorney, what if the estate, for some reason, to settle that has been dragging out for a couple of years? Is it still going to be the same power of attorney, or can it change?
So a power of attorney is only good for as long as that individual is alive. So when it comes to a healthcare power of attorney, there are a few limited powers that extend beyond death, and that usually has to do with maybe an autopsy or funeral arrangements and handling those type of things.
And then the trustee takes over after the person passes.
It could be a trustee, it could be a will, which is then a personal representative.
Okay.
Sometimes a lot of people will have transfer on death or payable on death or beneficiary designations, and then
I know that one.
Yeah.
TOD.
Yep.
Now we're talking about estate administration.
That's way different.
Guardianship, estate administration, they do merge a bit, and they certainly do in my office, because I'm handling estate administrations and guardianships and trust matters in my office. But in any event, they're related, but they're not the same. The powers that you get under power of attorney are different from somebody who's appointed by the court to administer an estate.
Which takes precedence? If somebody has both a power of attorney and a guardianship, which one takes precedence on decisions?
That's a question that's probably a better question than you had any idea before you asked it, because that's a great question.
It is an absolute great question.
And it used to be under Indiana law, I don't know when did this change, maybe 10 years ago, something like that, under Indiana, if the court appointed a guardianship, it just automatically eliminated any powers of attorneys that were out there.
I see.
But as we discussed a couple minutes ago, I said, no, now it doesn't work that way. You have to notify the power of attorney, and they be notified that the court's considering revoking your POA. And so theoretically, you could have a POA and a guardianship that operates at the same time. And I don't really know what happens then, but it can be a mess.
It can be a mess. Because oftentimes what I actually will see is that a family will come to me with an appointment of a healthcare representative.
Okay.
Because that's the only thing mom or dad were comfortable doing. I was comfortable allowing somebody to make medical decisions for me, but I wanted them not involved in my finances. Well, now they're at the point where they're incapacitated, and so I've got this appointment of a healthcare representative, so I have the authority to make medical decisions but not to deal with the finances.
What do you do?
So you can petition the court for a guardianship of just the estate. You could let the appointment of a healthcare representative document stand and that person make those medical decisions. Then either the same person or a different person in the family could petition the court to be appointed guardian of the estate.
So they would ask to be, you wouldn't be like appointing or suggesting?
No, because at that point, that individual wouldn't have capacity to sign a new document. And so we would have to go before the court to get the authority to handle those transactions.
You're reacting to that.
Yeah, no, that's true. And the opposite can be true, and I see the opposite true frequently, where the person has a perfectly valid power of attorney to handle business affairs, financial affairs, and things like that, and they'll continue using that. And I'll appoint that same person, though, to give them the powers to make healthcare decisions, because they don't have that already. So, and so the POA can be the same person as the guardian. They operate, they have one set of authority under the power of attorney that relates to one area, either person or estate, that's how it's described in the business, so to speak. And then they have one kind of authority that the court grants.
Okay, 38 years you've been doing this?
Almost.
Almost. Okay, so in that time you've experienced almost everything, although I'm sure new things come up as the world changes.
They
but
do.
What are some of the, I don't know that I want to use the word mistakes, but situations that people have problems with?
Well, families...
Should I say mistakes they make?
When money is involved, Sandy, and when siblings who have not always gotten along all their life, are involved. Things that have nothing to do with the guardianship, something that happened 30 years ago, can cause conflict when it comes time to. There may be general agreement that mom or dad, and this is the most common situation. It's a child who's petitioning to be guardian over their elderly parents, or one of their elderly parents, and. Those situations can go sideways pretty fast, but the issues don't really necessarily have anything to do with the guardianship, but people, they just kind of want to fight, and when money's involved, and
Yeah, we've talked about that before,
those can
when we
be
talked
sad
about
situations.
probate even.
But most guardianships are good situations. They lead to good results. People need the help, and we've referred mainly here to guardianships over adults.
Okay.
But I do guardianships over younger people too. First, there are guardianships for children. Sometimes when their parents are incapacitated, unable to perform their function, we'll appoint aunt or uncle or grandma and grandpa to be guardians over minors. But some of the most heartwarming stories I see in my court are children who have aged out, but they are developmentally disabled, but they are technically adults when they reach the age of 18.
And then
their parents no longer have a technical right to like medical information and things like that because they're an adult. Well, the court has to make a determination that they are incapacitated under an Indiana law, and usually will appoint their parents. They're the ones that petition to continue to serve as their guardians, to keep doing what they've done their whole life. And those are just.
But you have to if they've reached 18. You have to do
exactly. But those are usually just I marvel at the compassion and care that these people have for their children, and I just love having them in the courtroom. They're usually just those are happy situations.
Good.
I brought a tear or two to my eyes at time, and my court reporter, and those can be great situations.
Let me ask this: if you have granted a guardianship to parents of a special needs or a disabled child that's reached adulthood or 18, is that for life, or do they have to keep going back and get approved again?
It goes until terminated by the court, so it is indefinite. Yeah.
Okay.
But it can be terminated if and it happens. Typically not with somebody who's developmentally disabled, because it's highly likely that's going to be a lifelong condition.
Yeah.
But we have situations where individuals have been in accidents, maybe they go in there in a coma or something, but they are recovering, but they need a guardian before they recover, and then we terminate those, and have done that at the time when they regain their competency.
Okay. Have you ever had that situation, or what's unusual for you as an attorney?
Terminating guardianships is an unusual thing for something beyond somebody passing away. For the most part, that is a unique situation. Occasionally, too, what we get, I would say, is another unique situation is where people are either moving into the state of Indiana or out of the state of Indiana. That takes a little bit more coordination than I think most families recognize.
Okay.
And so if you are appointed guardian of somebody and you are wanting to move them to another state, not only do you have to handle that here in the state of Indiana, but then also in the state that you're moving to. And most of that is usually prior to the actual move. And so you really need to kind of know the rules of both this state and then the state you're moving to. So that takes a lot of coordination. It's not I'm just going to up and move in 2 weeks or in a month. And so I think that's kind of some of the more unusual situations we run into that needs a little bit more, kind of planning.
Guardians are under the jurisdiction of the court, and they remain so. So
always, forever.
The Indiana statute says that you can't leave the jurisdiction, basically, without the court's authority.
Oh, really?
So, I mean, you could if you were on a trip and you're intending to return.
Temporary.
That's there is common sense in the law at times. But if you're planning on permanently moving, there has to be a notification, there has to be a petition filed with the court. The court has to approve it. In all likelihood, the court will approve it if it makes sense. But sometimes there have been sensational cases, where people are trying to hide grandma or something, and they don't want the other,
where they are, where they're
try
going.
and move to another state, and so it just has to be transparent.
Do they have to go before the court then at their new location?
In all likelihood, that will be required. Because they're going to have to establish jurisdiction for their case in that other court.
You wouldn't be notifying the next court or the next person.
Not direct, but my order will become part of, I'm pretty sure, of that proceeding that says you are authorized to move to the state of Kentucky or whatever.
But you have to do this.
Yeah, and there are reciprocal compacts between states that deal with such issues.
Yeah.
So even though it's all state law, and it's not federal law, it's state law, but there are standard provisions that most states have in that area relating to the transfer of guardianships.
Okay. How long does it take, Jessica, to set up a guardianship? I'm sure that there are some of you out there now that are thinking, gee, this is something that I really need to do for my family or, my children, even if they're adult children, whatever. How long does it take?
It is case specific. It really is fact and case specific. But I would say there are a couple kind of things that you have to make sure you have. You need to make sure you have medical evidence of the incapacity. And so that's working in theory with a physician's office. And so sometimes those things can take a little longer. Sometimes we have to get the court involved even to have an assessment of somebody. And so proving the incapacity does require evidence of it, and that can take some work to get that. So that is I see that vary all over the place. You do have to provide notice to certain parties in a guardianship, and so you've got to make sure that you've given them notice of the proceedings and their right to maybe either be heard or object or to that nature.
So do they have to give permission? I mean, say I want to appoint somebody as a guardian for my children or whatever. Do I have to ask that person, will you do this?
Well, in a perfect world,
in a perfect world, which we don't have.
From my perspective as somebody who is helping somebody obtain a guardianship, it is much easier and smoother for everyone in the family if we're all on the same page and we do have that consent. That is not the perfect world though, and so sometimes there is no consent, sometimes there is an actual objection, and we just have to work through those things.
Okay.
And usually it's the court that may have to end up working through those things.
To
of course,
make the
from
decision.
the court's perspective, I like to see consents from all the interested parties as well. But sometimes people just flat out won't sign, or they won't sign them, and they live, they're not attentive to their mail or something like that, and they won't sign a consent. They may not even be against it. In fact, in most cases, they aren't against it, but they just never sign or return the consent. But that's okay. In a way, that's okay, because what happens is they have to get notice of the hearing, and if they don't show up, that for the hearing to object, that's considered to be a constructive consent by the court.
All right, so
they
if
were
you're
notified.
not here, you aren't objecting.
Right,
Okay.
exactly.
Okay. All right, well, as far as being before you or before the court, is there anything a person needs to bring to you paper-wise or approval from the rest of the family? What do you need?
Well, you're talking about consent documents there.
Yeah, those are done by mail?
But the lawyer's office will coordinate
Take care of that?
sort
Okay.
of thing, absolutely, and try and obtain and every situation's a little bit different. They may say, oh, if it's your next door neighbor, or if your brother happens to live in the same neighborhood, go get this consent signed by him. So, but it's a document that they'll create and have them sign. So.
Okay. All right. Now, here's a question. I know that during COVID, you did a lot of your work in guardianships online.
We did.
Zoom
hearings.
Do you still do that? Or is some of this done by mail now, or what?
I've done everything I can to get my court back to normal. I think it was a pretty remarkable thing that we did. I never missed a day of work during COVID. Never got behind in hearings. In my area, it's a little easier than some of the other areas of the court that do jury trials.
Or attorneys like
jury trials
Jesica
could not. Yeah. But it's a better hearing. It's a more. I think it's important that people be in the courthouse. So I've done everything I can to get people back in the courthouse. But we are still authorized under circumstances to do things by Zoom or by phone. But
it's a crazy world now, isn't it?
It is. It is.
Steve called in, by the way, and Steve has this comment and question. He said, I am guardian for my disabled son. What would happen if I pass? I have another son. Does he need to do anything to get guardianship transfer if I pass? How about that?
Well, there's
Who wants to take that?
We could write a book on this one a little bit, because there are various strategies that Steve might want to employ. What would be the first thing you would tell Steve?
Steve, the first thing I would tell you is to plan early and to start planning now. A lot of times what we'll do is during your lifetime we'll appoint a co-guardian so that it is a seamless transition. That way the court knows that your son is familiar with your other son and that they're familiar with the care, and that really this is going to be a smooth transition should something happen to you, whether it's in an incapacity or a passing. Because we really want to make this easy for the person who is incapacitated and has the guardianship over them.
Okay, we have about 20 seconds.
Oh,
what last bit of
flies.
information or advice would you give people on guardianships?
Well, guardianships can be emotional situations. In fact, they almost always are. But it's nothing to be scared of, and it's an area of the law that's well developed. It's been around forever. There's a good process in place. If you get good legal advice, you'll get through this process.
Get through it.
Yeah.
Eventually, you'll get through it. And again, I appreciate all the information and education that the two of you have shared with us tonight. And for the rest of you, I'll see you right here next Wednesday night at 7:30. Stay safe and stay healthy.
The preceding program on PBS Fort Wayne was made possible in part by
Beers Mallers, elder law attorneys providing information on legal matters of guardianship and financial issues relating to nursing home care. Beers Mallers attorneys can also assist with Medicaid requirements and help navigate difficult family situations. Offices in Fort Wayne, LaGrange, Warsaw, and online at beersmallers.com.